Court will note the appearance of Mr. Schaefer on behalf of the plaintiff and Ms. Greenlee-Clore on behalf of the defendant. This matter is before the court on the defendant's motion to resume court-ordered parenting time. Ms. Greenlee-Clore, go ahead.
Thank you, Your Honor. We're here again on this motion. My client has had this child, primary physical custody of this child since 2013. That was due to Miss Bailey having an insecure household, her having some mental health issues, and her threatening to abscond from the state of Michigan with a minor child. At this point, my client is just trying to get his son back. The parties agreed that while this matter was being sorted out, that Miss Bailey would have the minor child stay with her aunt for a weekend until they sorted this out. Shortly after that, the child arrived at the aunt's. Stephanie went and hired an attorney and filed this ex parte motion. This was never an agreement of the parties that this child was going to go and stay long-term with mother, or that the child was going to somehow start attending school in a different school district. Mother has withheld this child for 3.5 school weeks at the end of the school year, didn't take this child to school at all. This child sat at home. This child has now been interviewed by CPS in her home when that's what she's saying that my client's going to do. And at this point, she's completely withholding this child. My client just wants this child back. Essentially, custody has been changed without a full hearing in this matter. Based on the response here, it looks like Stephanie has now enrolled the minor child in schools in Springfield Middle School. There's no motion pending to change schools here. This child needs to be returned, frankly, to my client immediately. This child is in danger at Stephanie's house. Stephanie has now allowed this child to be interviewed by CPS in her home. She's talked with CPS in her home. And everything that she's alleged that has kept this child with her has now happened in her home. This child is not safe in her home, obviously. She's not protecting the interests of this child in her home, obviously. She apparently plans to change the school district of this child without permission of my client or this court. She's withheld the child from school for 3.5 weeks. This child was an AB student. We don't even know what happened with his grades yet for the end of the school year in Allegan County, but he probably needs to be in summer school. Stephanie hasn't talked to my client or won't talk to my client about that. At this point, there's no reason this child should be withheld. This court last ordered that my client show proof that the CPS investigation and criminal investigation were over. However, there were no investigations. We can't show any proof that these investigations were happening or that they're over because they never happened in the first place. The police did initially do a forensic interview with the minor child, but that's it. Nothing was found. Nothing's going forward. We don't know what happened with Stephanie and her having CPS in her home, but it can only be presumed that it's due to the condition of her home and the concerns in her home that are long-term. And again, this court removed her primary custody for a reason. This child has lived with my client since 2013. There's been no motion to change custody at this point. She has had temporary care of this child pursuant to the court order. At this point, this child needs to be returned immediately to my client's household. My client hasn't had contact with this child. My client hasn't seen this child. This child needs to be returned. If this court wants to do an evidentiary hearing on this, we can certainly move forward at that point. But on a temporary basis, this child needs to be returned to his primary established custodial environment with father. Thank you, Your Honor.
Thank you. Mr. Schaefer?
Your Honor, these are the same issues that were brought up on the ex parte motion and the reconsideration of that. The circumstances were that there were allegations as set forth in the emails from the defendant's household that there was an allegation of a child in his home against this child as to improper touching. And as a result, the CPS got involved, the police got involved. And as a result of the emails whereby the defendants indicated that they were going to have the child talk to the CPS and the police, was not in the best interest of this child and was not protecting this child. And that was the purpose of the ex parte motion. As a result, the child hasn't talked to the authorities in this regard. The matter is still pending. The fact that the amount of time has gone by is not demonstrative of it not going forward. And to place this child back in the same household where we have the accuser in that household is not in the best interest of this child at all. This child needs to be protected, and that was the purpose of the ex parte motion. And I think it should continue until there is absolutely no chance that this is going to go forward. And to put the child back into a household where the accuser is still in that household of children is not appropriate for this child. My client has done everything that she can do to preserve the education of this child. She's looking forward for the education in the fall. The child has gotten credit for the year. He is a good student, and to place him back in that household where you have an accuser and you have an ongoing investigation is not appropriate. So we're asking that this matter be dismissed for that reason, and also it's the same allegations that we had before that's been denied.
Your Honor, if I
Hold on, who is the accuser and how is he related to, again, the defendant?
I believe it's one of the children in his home.
That's not true, Your Honor.
Okay. Well, what's the accuser's name?
Your Honor, there is no accuser. The minor child at issue here is the one who indicated that he might have done something wrong. The child that he indicated he might have done something wrong to is 3. The child went through a forensic interview and nothing was found in that forensic interview. I want to bring the court's attention to paragraph 9E of mom's response here, where she indicates she talked to CPS and the minor child talked to CPS with her.
Not concerning this matter, Your Honor.
Okay.
And that just further indicates that mother has CPS involvement in her house, and which is one of the reasons why the child was removed in the first place.
Well, we don't know that. It's all just guesswork at this point. So, I mean, we can utilize hyperbole all we want. There's no allegations or anything of that particular nature. Well, the court did initially, when the court did the order, again, keeping the child in the care of the plaintiff, there were obviously some allegations at that particular time. Again, I wouldn't, this matter came back before the court on basically a ex parte motion. I don't look at those as the same as motions that are brought where the parties have opportunity to each, again, allege and to respond. So that is the reason, obviously, that the defendant's motion for ex parte relief was denied, is I wanted to have a hearing on it. I didn't want, again, additional ex parte motions just going back and forth in the case without any time to have any response. What I'm going to do in this particular matter is, obviously, the child is there's a provision under the other order for summer parenting time. The court is going to continue whatever the summer parenting time is, that would again, that would commence and continue through the summer immediately in this particular matter. I'm going to then allow the current order, the order for custody, meaning the order, not Mr. Schaefer's order, but the other order, to go back into effect. Court will reconsider that if in fact there is something substantial that comes out of a CPS, but if there isn't, then the court wants to put this back on the appropriate footing. And there is, as Ms. Greenlee-Clore states, there's no motion to change custody, so I'm not going to do it under the guise of a pending CPS investigation that may or may not proceed and may not be fruitful in any way. So at this point, do you understand? Again, it's kind of convoluted, but do you understand, Ms. Clore, what I'm saying?
It's my understanding that so I'm looking at the old order here from 2013. It indicates that the parties would exercise week on, week off during the summer.
Yep.
Ms. Bailey's now had the entire summer. Will my client now have his half of the summer, or will they start week on, week off immediately?
We'll do the week on, week off. I can always address any makeup at a future time. So we'll do the what day do they exchange? Is it a Friday or a Saturday?
Cody, what day do you guys exchange? Just word it.
Friday, and generally Friday to Sunday on her weekends.
Okay,
Well, no, during the summers. Have you guys been doing week on, week off during the summer?
Generally every summer we've been doing half on, half off. We never really did the whole week just because the transportation was easier, but we continued our weekends through the half of summers.
Okay,
We
well,
won't-
do you want, I'm sorry, go
well,
ahead.
let's do this because apparently we can't agree. The court will do the week, as the order said, alternating weeks, starting this Friday where the child will go back to the defendant. And at the end of the summer, then he currently has custody, so the child would stay with him at that point, unless something else comes up with CPS. So, Ms. Clore, you can prepare that order and submit under 7-day notice of entry.
Thank you. And if I could just specify 6 PM on Friday?
Yeah, 6 PM on Friday is fine.
Okay, thank you, Your Honor, I will.
Okay. Mr. Schaefer?
Stephanie, give me a call, please.
Okay.
Yep.
Okay, thank you. We'll conclude this matter at 9:11 AM. You're free to go. Have a good day.
Thank you.
Thank you.